Via telephone. Good morning, Joe.
Good morning, Rob. You know, when I make decisions about purchasing a vehicle, I always kind of look at the last vehicle I owned and did I get my money's worth? And I look at, what I spent on the car and how many years I held the car, how many miles I drove it. And, you try to make an economic decision when you're making such a big purchase. And I just wondering if you ever sat down and calculated the cost, the true cost for the car that Honda that you've driven for almost 400,000 miles. It has to be a minuscule amount.
I have made out big time on this purchase. I'm not going to lie. I know I have. And here's the reason why. So in 1987, I bought a Volkswagen Jetta. And I had that Jetta until 2006. And I put 396,363 miles on that car. Now, just my last mechanic's visit, my mechanic gave me a 400. He said, "Welcome to the 400,000 club." And he gave me the bumper sticker. And I said, "Oh, no. You just
It's a jinx.
jinxed me. And he goes, "Oh, don't worry about it. This thing's rolling. You're fine." He goes, we got, because they had, there was Mark I Volkswagen in Walkersville, Maryland, and they had different clubs for mileage levels, right? And the car died at 396, 363, and I never got to actually really earn the 400,000 bumper sticker. So I thought to myself, I'm never going to have another car that's going to last that long. I mean, at that point in 2007, I was 2006, I was 43 years old. I think I'm not going to have a car for 20 years after this. It's just not going to happen. Well, then I just kept rolling this thing up and down I-70 and I-81, and next thing you knew, it had a bunch of miles on it. So I'm well ahead on it financially, and I've got great mechanics who work on it. They are honest as the day is long, and I take it to them, and they keep it rolling. Right. Yeah.
Well, as you know, the expense of buying a new vehicle, no matter what you're paying for maintenance and all the things on the older vehicle, is never going to, unless it's something major, like unless you lose the transmission and those kinds of things, it's just not going to pay to buy a new vehicle instead.
Well, I got a couple of Italian mechanics. They're brothers. They get in there and, if it ain't broke, don't fix it. That's their theory.
Amen.
Right? You find yourself a couple of good Italian mechanics and you got yourself a car that's running up and down the road.
Run forever.
I try to keep the money within the family, Bill. You know what I'm talking about?
I do.
Yeah. Hey, a couple of things here just to clean up real quick from our last segment there, some texts that I was receiving here. So from John Alderton, who had a career in the Guard. He said, we had to scramble to find a location after 9/11. I was president of the Apple Harvest Festival back then. This is dealing with the Air Guard as a location. So 9/11 was part of that. And also, I want to, if I can go back far enough in the comments to find it. Here it is. Al Rochek. I was on the USS Rourke when the engine room went dead in the water. We were just across the international date line. I don't know if you saw that comment or not,
I did
Bill.
see that, yes.
Yeah, so just a couple of notes from our earlier half hour of conversation. Now, Joe, the reason why we brought you along here on this conversation, and Bill suggested it, and I thought, well, that's a great idea. And it had to do with some of the different legal decisions that have been going on, and one of those was Judge Frobel in West Virginia, and a decision that he had made recently regarding vaccinations and such. So, Joe, why don't you kind of take it from there?
Yeah, to try to make sense of all this at this stage is a little difficult because it is still a moving target in terms of figuring out where this is ultimately going to end up. Now, predictions are clearly that it's going to end up before the West Virginia Supreme Court, but where we are now and where a lot of the focus of the state is currently set is on Raleigh County and Judge Frobel. The most action in his courtroom by far on this issue, and what he has recently done, and it's an interesting move, he has entertained and now granted class certification status for the approximately 570 students statewide who have filed with the state health department for a religious exemption to the compulsory vaccination law. Now, so what that, and by the way, I have not seen a written order yet from the judge. He ruled from the bench just days ago that he was going to grant class certification. So we don't have an order yet to review, or at least I don't have one, to see what his reasoning is and how this class is going to actually operate. But he has indicated clearly that he is going to ultimately issue or deny a permanent injunction against the State Department of Education on the enforcement of compulsory vaccination laws in the state. He's going to ultimately rule on that, and his ruling will have statewide effect unless the class certification ruling itself is challenged. So there's a lot of moving parts here, but that is the most current, up-to-date action that has taken place in Raleigh County. And recall there that initially that case in Raleigh County had to do with some students who were being told they were going to be denied admission to the Raleigh County schools because they were not vaccinated. They sought an exemption under the Religious Freedom Act law that is been on the books in West Virginia since 2023. And the court entertained their motion for injunctive relief. And after that, he consolidated a case. Another case was filed in Raleigh County by two students who claimed that they had compromised immune systems, and allowing unvaccinated children in school was going to be potentially harmful to them and deny them the ability to attend school. So all of that is now pending before Judge Frobel. I thought it was an interesting move by the plaintiffs to seek class certification because Judge Frobel had indicated or had signaled that he was leaning towards granting these religious exemptions. That seemed to be the tenor of the hearings held so far. So I think the plaintiffs in that case who were seeking an injunctive relief against the Department of Education saw an opportunity to have this judge decide the issues on a statewide basis. And that's why the class certification motion was made and now from the bench ultimately granted.
Joe, if in the next legislative session a different vaccine law is passed, maybe one similar to what they tried to pass last year, does that alleviate any of these court decisions, the pressure on them from being made?
Well, they're in the grand scheme of things, there can still be legal challenges to even enactments from the legislature. Because you're dealing with potentially constitutional issues, constitutional protections here, both on a state and federal level. So while the legislature can come in and is expected to take this issue up again next session, that might not be the end of the fight. But clearly, I think the courts are looking, and when I talk about the courts, I'm talking about the circuit court level now, the county courts. I think the courts are looking to have the Supreme Court ultimately address these issues, and I think the courts are also ultimately looking to the legislature to perhaps provide further clarification about how these two laws, the Religious Freedom Act law and the compulsory vaccination law, how they're going to work together in concert regarding admission to public schools. So bottom line here, I think we're going to have to wait till sometime in the winter to see where this goes. It was interesting to me that some of the briefing schedules that have been set for the appeals of some of the rulings from Raleigh County and Judge Frobel, the briefing schedule was set to conclude at the end of February. So perhaps even our West Virginia Supreme Court is waiting to see if the legislature takes up this issue.
Yeah. Joe, thanks for clarification. I read the Metro News article on this, and I got totally confused. You've done a lot in trying to explain it. There's another aspect as well. Judge Frobel made no distinction, I believe, correct me if I'm wrong, between religious exemptions and philosophical exemptions, something that the Attorney General has also been saying. No distinction at all. Is that correct?
That is correct. Judge Frobel has pretty much said that those two are synonymous, the religious and the philosophical objections. And as a matter of strategy here, if you're inclined to not have your children vaccinated and you cite a religious reason, you know that that's going to be not on the most solid of ground, because there is a dearth of evidence out there that religions or certain religions are opposed to vaccinations. They're just, in terms of organized religions, I'm really not aware of any. So that's not the most solid footing for these folks who are seeking these exemptions. So they want to include the idea that there's also some conscientious or philosophical objection to the vaccination orders and the compulsory nature of those orders. And I think the strategy legally here is to have those be seen as synonymous, so that the law is as broad as can be in terms of what exemptions are out there.
The fact that the Judge Frobel made this a class certification, and you said it applies to the state as a whole, does that in fact make Judge Lawrence's opinion null and void, since his opinion was contrary to what Judge Frobel says?
Well, not yet. And do understand, Bill, that what is pending before Judge Lawrence initially was a motion for temporary injunctive relief, or TRO, and Judge Lawrence denied that. But even in Judge Lawrence's courtroom now, there is still briefing that is scheduled, and there's a hearing set, I believe, in November, for the parties to come forward with additional information, additional evidence regarding their respective sides of the case. And Judge Lawrence did that because oftentimes a petition or a complaint filed for injunctive relief is deemed an emergency, at least in the court system, and hearings are scheduled as soon as possible to hear the parties on the nature of their claims or their objections to the claims. And Judge Lawrence, rightly, in my opinion, decided that, well, look, I'm not going to temporarily suspend the operation of the Berkeley County schools in terms of vaccinations. I don't see enough evidence yet, but I'm going to give the parties additional time to flesh out their respective arguments and appear in court at a later date. And I believe that's going to happen in November.
November the 12th, I think, according to Jackie Long. But let me ask you a question a different way, Joe. The class certification, what influence does that have on all the circuit courts throughout the state?
Yes, right. To your question, Bill, which I know that's what you posed. And let me say this. If the class certification itself is not challenged, or it's challenged and upheld, and there is, in fact, now a class of, again, over 500 students in Raleigh County, and these students are statewide, then the decisions of the Raleigh County judge will have statewide effect, and it could serve to overturn or abrogate those orders coming from other circuit courts. So that is if you would, pardon the expression, a little bit of a judo move here that took place in Raleigh County. I believe the plaintiffs found a judge that they were hopeful was going to see things their way, and that's why they moved for class certification. Very interesting move, and if the judge issues an order and it's not challenged, then what happens in Raleigh County will have preclusive effect on the other circuits.
Maria.
So I was going to ask this clearly. I'm not going to talk about the Berkeley County case for obvious reasons, Joe, but in terms you kept using the words interesting move, and you're someone who I think has had some experience with class action suits, and so do you think this was, besides being interesting, just a good move, or you talked a little bit about how you believe it will play out, but talk a little bit more about the whole premise of a class action suit here.
Sure. Yeah, it's Rule 23 of the West Virginia Rules of Civil Procedure. So it is something done in both the state and federal courts, because there's a similar rule at the federal level. And class actions are typically looked at with favor whenever there are a couple factors present in a case. And one of those is numerosity. If there are a number of similarly affected people, similarly aggrieved people, oftentimes a judge will say, well, upon motion, because the judge often does not do this on his or her own, but judges will look at the situation, and if they get a motion for class certification, they will see, okay, are there a number of people who are in the same boat here? Are there similar questions of fact and law? And there's another term is typicality. Okay, are we looking at a situation where pretty much the same questions of law and fact are going to be arising in these cases across the state? Are there numerous people who are being similarly affected by those laws? And if so, the judge can issue an order certifying a class and saying, I find that there are enough similarities here, both in terms of the parties affected and the laws involved, to certify a class and handle it all in one courtroom in one case. Oftentimes that's favored because of judicial economy, and it's also favored because you avoid the risk of inconsistent decisions across the many state courts. And I think we have that here. In my opinion, there's enough numerosity, typicality, and commonality for a judge to say that pretty much all the issues and the legal questions and the number of people affected, they're all going to be citing to the same laws, making the same arguments. And so it makes sense to have it in one court under the umbrella of one case. And while it might be challenged in terms of whether this is an appropriate class certification, my reading of it, and based upon the reading of filings across the state in different courts, it's pretty much the same arguments that are being made across the board. So I think the class certification may be upheld.
Joe Ferretti, our guest here on the program. Joe, let's switch gears and go to a different case and talk about Alex Jones and that decision that we just heard about here, too. This was a case that was involving billions in settlement money, Joe. And what was the recent decision there, and did it raise any eyebrows?
Well, it did in one sense, Rob, but, as we like to, especially I like to give a tip of the cap to the U.S. Supreme Court, because their decisions are certainly life-changing in many respects for all of us. So we try to keep an eye on those things. And I think the Alex Jones case, and recall that was the case where he was unabashed in questioning the truthfulness and the veracity of all the reports coming out about what happened at Sandy Hook Elementary School and the murdering of those 20 students up there by the lone gunman. The parents of those deceased children sued, claiming that they were harmed by Alex Jones's defamation and by his false reporting. And jury awarded $1.4 billion against him and his production company. He has appealed that up and down the court system. And eventually the Supreme Court has made a decision not to review the final rulings of the lower courts upholding that award. So while Alex Jones' production company, they're all in various stages of bankruptcy and things of that nature right now, what's going to stand is his liability for publishing false or demonstrably false information about that tragedy at Sandy Hook Elementary. So that case is no longer going to be on appeal, and there's going to be a collection effort now on some of that money that's owed out of that $1.4 billion to those families.
Joe, so we got into these freedom of speech issues, and when is the ability to hold someone to the truth and affront to their freedom of speech rights? So what caused this particular case to go against Jones?
Well, remember, Rob, there's a different standard in terms of whether the subject of the speech is a private or public individual. A politician, unfortunately, has to take more slings and arrows than somebody in private life. And these parents clearly qualify as private individuals. They are not public figures. So the standards in terms of information that are published concerning their lives, their situations, the standards are a little higher for those who bring forth such information or publish it. And in this case, Alex Jones and his production company was unable to establish any real proof that the shooting at Sandy Hook Elementary was a staged event, that there were actors involved, that it just wasn't real. And that was a lot of what he was, if you don't mind the term, spewing forth on his radio show and his television show. And so when you're a private figure, it's not as big a hurdle to establish that somebody has been reckless with the truth or the lack thereof. And in this case, the parents were able to establish that they suffered great emotional distress over what Alex Jones had done, causing them to relive that whole event and causing them to be questioned in their own community about what happened. So it was the kind of case that you see often when private people are the subject of the information. The proof has to be pretty strong that you know what you're talking about when you make those kind of accusations. Clearly, Alex Jones was unable to do that.
And realistically, for these parents, the win is the thing, because the ability to collect $1.4 billion from Alex Jones is
not going to happen.
not yet.
Yeah.
No, he not this sum. Now, he had a very profitable business and many other businesses. I think he was selling health stuff that you get at a health store and things like that. So he had a profitable enterprise going on there, but not to the tune of $1.4 billion.
Joe, staying with the Supreme Court very quickly before we run out of time. 2 years or so ago, the Supreme Court ruled against Alabama for voting right redistricting. The same issue is coming up now with Louisiana. What's a possibility, or what's the likelihood of them reversing themselves with Alabama and supporting a practically identical case in Louisiana?
And you have 45 seconds, Joe.
Yeah, Louisiana versus Calais. We're going to keep our eye on that. Section 2 of the Voting Rights Act is the subject of that case, and that's a case where Louisiana attempted to establish black congressional districts that were majority black, so that you're almost assured of having a black representative. There's arguments about racial discrimination and how they did those congressional districts. And frankly, I think the U.S. Supreme Court is probably going to take the final swipe at the Voting Rights Act. Section 2 is all that remains of that act, and I fear that that's going to go away as well. And they're going to mostly leave it to the states to decide how to draw these voting districts.
Joe, thank you kindly as always. We'll speak with you again Friday morning.
Okay, folks, enjoyed the discussion. Thanks.
Have a great
Thank
day.
you.